Okay, good afternoon, or good evening rather. Good evening all. Okay, we are welcome to what is the first joint COP meeting. Joint in the sense that we have both legal and HR COP members here. We're here today out there in the outer world. And so today we'll be looking at contemporary developments in Nigerian employment law. And in choosing the facilitator, we had to take into consideration a number of things. The facilitator we chose is somebody that is always, coming up with a lot of ideas and, up to date on a lot of issues, especially legal issues. And by the time we deliberated and agreed on this topic, we agreed that no less a person should be invited to talk to us on that. I would not prejudice the introduction of our facilitator today. All I'll do is to urge us to listen well and try as much as possible to take as much as he will be able to share from this session. I will invite Obong to formally introduce the facilitator to us. Thank you, Obong.
Good afternoon, all. I'd like to introduce our facilitator for today, Mr. Unduka Ikei. Is in the law firm of Ikei and Ari Fanyo and Co. I hope I got that correctly. He's a man of many achievements in terms of over the years. He has 20 years legal experience. He has been involved in the public sector, in lecturing. He currently also lectures in UNN. He has also been involved in teaching, research, litigation, commercial and corporate and legal services, and also tax. He has worked in several places, which would, from looking at where he has worked, you can see that he's a man of many, many talents. He used to be in KPMG, also at Anderson. He went to the university. He obtained his degree from the University of Nigeria in Nsukka, and he obtained his master's from the London School of Economics and Political Science in 1994. He's the founding partner of Ikei Afriya and Co. And he was also the Attorney General and Commissioner of Justice one time in Enugu State. Mr. Unduka is also a member of the Chartered Institute of Arbitrators and London, and a fellow in the Chartered Institute of Taxation of Nigeria. He's also an honorary fellow and Association of Fellows and Legal Scholars, Center for International Legal Studies in Austria. He has published several articles, local, international, which have been featured in foreign and also local business and commercial journals. Without wasting much of your time, let's just welcome. And let me just say something again. This is not the first time he's coming here. He's always ready to support us, and this is free. We're not giving him anything. He's always just ready to listen to our call and just come and speak to us and teach us more about any aspect that we think is very important to the group. Without much ado, let me just welcome Mr. Unduka on stage.
Good evening, ladies and gentlemen. This is the second time I'm coming to join in this knowledge sharing event. I think I'd rather keep it at that level. That's knowledge sharing. I don't come to teach. When I go to the university, then I teach. But when I'm in a place like this, I think it's more of knowledge sharing. And even in the university where we say we teach, I tell the students that, look, one of the reasons why I enjoy teaching is that I learn. If you have a very good class, by the time they ask you questions, you go back and you take another look at what you thought you know, and then you discover that you learned something new. So I hope that I'll take something away from this session. What we have today is looking at what has been happening in the Nigerian employment law scene, particularly since 2011, when we saw a shift from what used to be the case to a different body of jurisprudence and some different kind of philosophy, underlying labor and employment law corpus. Sorry, how does this work? Okay, good. So the outline will be, I'll look at basic introduction of concepts. Then I'll look at National Industrial Court before the third alteration. Then I'll look at what labor and employment law was in Nigeria before that alteration, just to create a background and to see how we've moved since 2011. Then we deal with what we think are the changes that have occurred on the back of the third alteration, and then how the NIC has gone about its job of interpreting the new law, and then what we think is going to keep happening. I'm not sure. Okay. Now, what's the nature of labor and employment law? Labor law focuses on unions, collective bargaining and other issues, whilst employment law covers the relationship between an employee and an employer. Our focus today is going to be more on employment law, not labor law. Yeah, next slide. No, let's go back one slide. Back. Yeah, okay. Forward. No, forward, yeah. Good. Now, what have we seen in Nigerian labor and employment law scene? Now, both areas of the law have been governed by statutes and case law. And then we've seen developments through the case law being very slow in Nigeria until recently. And then we followed English principles. Now, the key and major changes we've seen have happened through the statutes, but until recently they were quite few. In fact, apart from labor disputes and unionism, the only piece of statute that we have in Nigeria regarding labor law is the Labor Act. Now, the Labor Act in itself is very limited in its scope. It applies only to workers, right, who essentially might be junior people. So, apart from the Labor Act, and apart from law relating to unions and labor disputes, we didn't actually have much legislation around labor and employment issues. So for this reason, labor law was fairly stable. You could predict, then what the courts would do. You had the right to fire, you could hire and all that. Issues were very simple. But then that stability was broken in 2011 with the amendment of the Constitution, the third alteration. And the history really was that gradually from from when you had the industrial tribunal, and then you had the industrial court, and then there was an attempt to make it a superior court of record, which failed. I think somehow the people who were interested organized a coup and went to National Assembly and then amended the Constitution. Yeah, next slide. Now, before the third alteration, the National Industrial Court was made a court of superior record by virtue of Decree 47 of 1992. And then it had exclusive jurisdiction relating to labor matters. That was what the decree intended to achieve. However, when the matter came to the Supreme Court held that the Constitution had defined what the Superior Court of Records were. And for that reason, and for the reason that the National Industrial Court was not one of those courts listed in the Constitution as the Superior Court, that it was not a Superior Court. So, and then it didn't have exclusive jurisdiction. So with that decision, the NIC became a tribunal inferior to the High Courts. And I think that was what inspired the third alteration. Next slide. Now, before the third alteration, employment law basically looked at hiring, recruitment, then conditions of work, then firing. Then labor law dealt with organization of trade unions, negotiation of CBAs, and then enforcement of CBAs, and settlement of labor disputes. Yeah. I think let's not spend much time on labor law issues because I understand that we have to do quickly. So, trade unions basically were regulated by statute. That's very clear. There was little common law rule about trade unionism in Nigeria. You know, we just had statutes dealing with registration, with membership, and all that. Next slide. Now, with regard to CBAs, the major issue there was that for a long time CBAs were thought to be binding in honor. So if a union negotiated a CBA with an employer or an employer's organization, all they had was a gentleman's agreement, and the only way they could enforce it was largely by way of strikes. And then individual staff could not claim on the back of the CBAs. Yeah, next slide. Next slide. Yeah. Now, let's look at employment law prior to the third alteration. I think this is where, and we're going to look at it in the context of hiring, conditions of work, and then firing. Now, under the old regime, an employer had the right to fire, and then there were little restrictions on what he could do and what he could not do. Now, there was no issues about discrimination, for example. Today, based on what we are seeing, it is possible for a prospective employee, someone who is not yet an employee in the organization, to sue the organization regarding the manner that the recruitment was conducted. He could say that it was discriminatory. He would say that it was not fairly conducted, right? Because labor law today deals with issues relating to employment, and the industrial court has interpreted that to mean issues prior to, and even during, and even after. So, next slide. Now, regarding conditions of employment, it was also fairly straightforward. Apart from the Labor Act, which had a few requirements regarding conditions of work, right? And like we said, Labor Act applied only to junior workers, not to everybody. There was not much in the body of our law relating to employment that required an employer to do any particular thing, you know, whilst employees were working. I mean, the only restrictions were some specific legislation like the Pensions Reform Act, the Minimum Wage Act, laws requiring compulsory insurance, and then anything that was illegal was otherwise. The employer was free to negotiate any agreement with the employee. You know, freedom of contract was the operating regime. Next slide. Now, firing. Also, it used to be said that employer had the right to hire and fire at will. You know, so he could fire for good or bad reason, or for no reason at all. The only restriction was that if the employer made the mistake of indicating a reason for firing in the letter of termination, then he'll have to sustain that reason. He has to prove it. But if he did not give any reason, then he had no duty to prove why he fired an employee. Also, in the worst case that termination is found to be wrongful, the maximum award of damages that an employee got was what he would have got if the employer had followed the procedure for termination. And so in most cases, if all the employer had to do for the employment not to have been wrongful was to give notice, maybe 1 month notice, and you went to court and you proved that the termination was wrongful, all you would get was payment of that 1 month notice. Now, yeah, just back. Yeah. Now, if the court found that the termination was unlawful as opposed to wrongful, then the court would order reinstatement. Now, you talk about unlawful termination in the context of an act contrary to statute, right? So because of that, it happened mainly in the context of government employment, what you may call employment with statutory flavor, right? So, and so in those cases, you could say that the employment was unlawful. And because it was unlawful, it was held to be void. And because it was void, then the court could reinstate because nothing actually happened. If it was void, it meant that nothing happened. Next slide. Now, what then happened when the third alteration passed? First of all, it confirmed the NIC as a superior court of record and gave it exclusive jurisdiction over labor and employment matters. Then it increased the scope of labor and employment law, thereby increasing the jurisdiction of the NIC. And this is where the issue is. And then empower the NIC to apply international best practices, international standards, and international conventions. So today, labor law in Nigeria is at large. Right. Okay, next slide. Now, we'll deal with those issues one after another. Section 254C1 of the Constitution, which is the third alteration, gives the NIC jurisdiction in regard to unfair labor practice or international best practices in labor, employment, and industrial relations, and the application of or interpretation of international labor standards. Now, 254C2 gives the court the power to deal with any matter connected with or pertaining to the application of any international convention, treaty, or protocol which Nigeria has ratified relating to labor, employment, workplace, industrial relations, or matters connected therewith. Now, before now, we thought that the only way conventions could apply in Nigeria was if they were domesticated, pursuant to Section 12 of the Constitution. So that convention had to come into the National Assembly. The National Assembly would then make it a local law. If it was a convention that had to deal with matters outside of the scope of the authority of the National Assembly, they would have to get the concurrence of the state's House of Assembly. But what the third alteration purported to do was to automatically domesticate all conventions that Nigeria has ratified regard to labor. My view is slightly different. My view is to try to strain this law to say that what it has done is to give them the power to apply, to deal with those matters, right? And not the power to apply a convention that has not been domesticated. Because it says power to deal with any matter connected with or pertaining to this or the application of this. So it didn't say that whether or not. So what it means to me is that it's only the NIC that can interpret those conventions if they have become applicable in Nigeria. That's my my view. And I believe that with what the Supreme Court has done with regard to the finality of the jurisdiction, that if a matter on this issue goes to the Supreme Court, one may be able to persuade them, because this is entirely different from our approach to international conventions. Nigeria is what you call a dualist state, not a money state, which means that for every international convention to become law and then give a private citizen the right under that convention, that convention has to become a local statute. Next slide. Now, Section 243 now give the NIC some power of an appellate court by basically saying that appeals would lie only in regard to matters relating to fundamental human rights as of right. So that before, before June or so, the NIC was the Supreme Court in regard to labor issues. Whatever they decided that didn't have to deal with fundamental human rights was final. But today, I think the law has changed, and the NIC decisions are appealable, right, with the leave of the Court of Appeal on every other matter apart from fundamental human rights. Next slide. Excuse me. Now, how has the NIC dealt with this new regime? Like I said, I think where the biggest power is today, or the area that is causing the greatest consternation, is the power of the NIC to apply international best practice, international standards, or conventions. And the first area where we saw the impact was in regard to termination, where in one of the cases, in Aloysius and I think Diamond Bank, one of the judges held that an employer must give a valid reason for termination. That, you know, in the past you could give or not give. If you gave, you had to justify. If you didn't give, you were fine. But now, an employer would have to give a reason. And that reason has to be a valid reason. Now, in getting to this point, the court held that this was international best practice on the point. Now, the issue is, if you look at the NIC, you look at the amendment, the NIC Act, unfortunately now, the NIC High Court rules. If you're talking about an international standard, it's a matter of fact. You have to show that this has become the practice all over the world, that it has now become a standard everybody has to follow. But in this case, there's no such, and if it's a matter of fact, then you have to prove it. Like, it becomes a custom. You have to prove it, like the Evidence Act requires that you have to prove every question of fact. But in this particular case, the court did not ask for proof. The court just relied on ILO convention. And this particular instrument is not yet a convention that Nigeria ratified. You know, so, and the court in that case held that you must give a valid reason before you terminate. Now, the NIC rules require that if you are relying on international best practice or international standard, you must have to call evidence to show that that has become, you know, widely applicable, you know, before the Nigerian court will consider whether that should also become applicable here. But then if you were relying on a convention Nigeria has adopted, then the court will apply it directly. But you will see that in no case up to date has the NIC applied a convention directly. Next slide. Next slide. This is just look it up. Okay. Now, on this issue of giving reason for termination, now there will seem to be some divergence of views, even in the court itself, right? Whilst Aloysius and Diamond Bank made it very clear that you have to give a valid reason for you to terminate, and if you don't, then the termination will be wrongful. There are other cases, at least 2 other cases, where a senior judge of the NIC did not quite say this. For that judge, he says this is an ideal that, you know, we should work towards. And in a paper that the judge gave recently, you know, he also stressed the point that as far as we're concerned, it's a matter of fact, and that his position is actually buttressed now by the NIC court rules. That it's a matter of fact that you have to prove that that a particular rule of or standard you want to enforce has become widely acceptable. And he says that, look, that the only way this can happen is if a lawyer comes to court and then he says this has become international practice, best practice, that he has to do a tabulation of the countries where those rules are applicable, right, to be able to show that the rule has actually gained some kind of widespread acceptability for it to happen. So that's the only way that you can actually prove that a particular rule of law has become international standard. But what I've advised our clients is to say, look, that judge will not sit on all the cases that will go to the court, Now, and that's one. Two, in the cases where he gave a different opinion, the issue did not arise directly. So, as lawyers, we say it's arbiter, right? And again, it's all the judges of the NIC, they're equal. And, a simple rule of law is that they're not bound by their decisions, right? Which is why some of us kicked against the finality of it. When individual judges are sitting, in different courts and they're giving different decisions, and there's a final court, there's a problem, because you don't know what to follow. Which was, so what I tell our clients is, look, if you want to sack, if you want, give reason, right? Just in case the matter comes before the judge who decides Aloysius' case. Because the judge is not going to change his position, right? He's going to insist that he is right, And somebody might say, okay, but then you have to, since the rules say that you have to then prove as a fact. Another lawyer can argue that we've gone beyond that because it is now the rule of law under Aloysius. So that we are no longer talking about international best practice. We are talking about a rule of law domesticated by Aloysius. So if I was arguing the case for an employee, I'm not going to be talking about international best practice. I'm going to be saying Aloysius has decided. So we've gone past the point of going to prove international best practice. Now, I think I made the other point about international conventions, that what we see today is different from what Section 12 of the Constitution tells us. And I'm looking for the opportunity to take the matter up, just the way the other one went up, and I'll say that, look, that Section 254 does not automatically apply conventions. That it gives the court the power to apply conventions if those conventions have become domesticated, Next slide. Like I said before, I don't know of any decision of the NIC that has applied any ILO convention as a convention. What we've always seen is ILO recommendations, ILO standards as international best practice. Next slide. I said before that it's possible that this will change because the rules clearly now have set down how you need to prove, how you have to prove international standard, international best practice. Yeah, next slide. Now, another area where we've seen the courts relying on international best practice to do whatever is in the area of remedies for termination. Like I said before, in the past, if termination was wrongful, the measure of damages was what would you have obtained if we had done it the proper way, right? And in most cases, it's notice. Because an employer has the right to hire and fire. And, it's a two-way thing. If an employee has the right to resign, right, then you cannot compel an employee who wants to resign to stay. It also means that an employer can also walk away from the contract, right? But the point is that if you have to walk away, you have to walk away in the manner provided for in the contract. And if the manner is give 3 months notice, and you give 3 months notice, then nothing, But now you have to give reason. So it's not just giving 3 months notice. So what we also told our clients is, you build up the case, right? This is no longer the time where people give verbal warnings. For anything you want to do, you document it, So that if you need to terminate, you can then have sufficient documentary support for your case. But if everything is oral, then it might be a bit difficult. Besides, like one judge of the NIC will also say, the employer has rights too. And, you know, all this issue of fair hearing is about, have you given someone opportunity? That the cases always say that the employer is not bound to accept the excuse given by the employee. So what's important is that the employer give the employee the opportunity. So there has to be a query, then there has to be a response, and the employer will say, no, I'm not accepting this. Yeah, but you just can't wake up and then say, okay, I'm terminating the employment because of this. You know, I'm giving you notice so you can go. So you have to have a reason, you know. Now, also, we used to think that reinstatement could only be ordered in respect of employments with statutory flavor, which were employments in government service. But then, if you look at the literature and the case law today, you will see that the basis for reinstatement is nullity of the termination, right? And nullity would follow unlawfulness. So if the termination was unlawful, then it was null and void. And because of that, reinstatement becomes merely a matter of course, because nothing actually happened. So what you've seen also is that if, even in private employment, the termination could be said to be unlawful, right? And it's possible. If, for example, you terminate on, if, for example, the employee is able to show that the termination has some coloration of discrimination, right? And then he ties it to the Constitution, that he breached his right not to be treated in a discriminatory way, then it will be unlawful. If it's unlawful, then it becomes void. And if it's void, they can get a reinstatement. Also, if you terminate someone's employment on account of his activities as a trade unionist, right? That will be infringing his right, both under the Constitution to associate freely, and under the Trade Union Act to join a union. So, in that termination, you have done something unlawful. So that termination will be void, and there could be reinstatement. So we're beginning to see reinstatement even in the case of private employment. So the cases are there. Next slide. So today the remedy for termination is not just payment of damages, right? It could also involve reinstatement. Yeah. Now, I've tried to distinguish between unlawful and wrongful termination. You know, so I'm not going to spend time doing that again. I mean, like I said, unlawful is when termination is clearly just in breach of the contractual obligation, but it's wrongful. But if it's in breach of statute, it's unlawful. You know, yeah. Now, what we have also seen is that the NIC has wiped away the difference in consequence between termination and dismissal. You know, before, what you saw in most employee handbooks was that if, I think you still have it, people who have not updated theirs, is that if you're dismissed, you lose your benefits, right? But then if what happens is termination, you then get your benefits. But the NIC has said no, that if dismissal and termination have the same consequence for an employee's terminal benefits, that any accrued rights will have to be paid. You know, so even if you have provisions in your handbook that take away an employee's right to benefits upon dismissal, the NIC is going to strike down those provisions. No. Whether it's right or wrong. Sorry? Since 2006. 16, sorry, in Boyo and LBM mortgages. Sorry? Yes. You see, when you terminate, in fact, you're going to see something more shocking, right? When you terminate on the basis of fraud, right? The employee has already earned those benefits, right? Now, if the fraud exposed the employer to some loss, right, you can quantify the loss and then net it off against his benefits, right? But that again is after you have given him opportunity to defend himself, and he's unable to defend himself. And you made a finding after following due process that he committed a fraud, and the fraud led to a loss of so much in quantum, and then he can then net it off his benefits. Then he will pay the balance. Yes. So there are two issues. One is his rights, and then his liabilities. Right. So you just bring the two together and then see who pays the other. Okay. Next slide. Fine. Anyway, it's just that I understand we have to be out of here by 5:30. So however you want to. At the end, we can then. Okay. Okay. Now, like I said at the beginning, employment law in Nigeria seems to be at large. Today, you cannot fully give opinion on any issue without reference to ILO. If ILO may not even be sufficient, because international best practice may not yet have been coded in any of the ILO instruments. So you also need to look at what's happening in jurisdictions that Nigerian courts are likely to borrow from. So what we do typically now is that you look at what's happening in the UK, and then maybe South Africa or India, and then make a comparison. But these are some of the instruments that I would think are very important: freedom of association, the right to organize, maternity protection convention, for the women, termination of employment convention, workers and family responsibilities convention, discrimination and employment and occupation convention, private employment agencies convention, and employment relationships recommendation 2006. So these are some ILO instruments. Every HR office now should have folders on ILO instruments. That's one way to be proactive, to proactively preempt the NIC. Next slide. Now, what do we think you're going to be seeing going forward? One, award of general damages. The NIC has begun to award general damages. And it's strange because in contract, strictly speaking, general damages are not available. Because the measure of damages in contract is basically what the claimant has suffered as a result of the breach, right? So the term general damages in contract is a misnomer, because you're always required to prove the quantum of loss you've suffered. So, but now in employment, which is a contractual situation, we're beginning to see general damages. And, I mean, there are cases where the courts have awarded 6 months salary, 3 months salary, 12 months salary, general damages. And this has happened in situations where the courts held that the manner of termination was high-handed. So it's not just that the termination was wrong, but it was high-handed. So they will have to, more like punitive damages. If they had used the term exemplary damage, that would have been better. But using general damages kind of, sends the wrong signal. Now, reinstatement, I mentioned that. Today, there's a chance that even in the private sector, an employee who is able to show unlawful termination might be able to get a reinstatement. Now, abolition of the distinction between consequences of dismissal and termination, we've dealt with that. What we also see that's happening now is the concept of constructive dismissal. I think it happened in one of your subsidiaries, Modelim and UBA. So the concept is that if an employee is forced to resign, directly or indirectly. Directly is that you call someone in and say you must resign, right? If you can prove it, then it's dismissal, right? 2, if you make the environment uncomfortable for the employee that he decides to leave, that will not be resignation. The employer will be held liable for that termination of employment, right? And it could be dismissal. And the employee will be entitled to the measure of damages available to an employee who was actually dismissed or terminated. So it's something people need to watch. In fact, that's happened in the Model and UBA, where someone was employed, and then it was that after a point you become this and then you become that. It didn't happen, and the man left. Right? The court held that because of that situation, that UBA constructively dismissed him from employment, and because again he could not be reinstated, the bank was asked to pay him what he would have earned. In fact, that's about one of the highest awards I've seen in labor law. I think it's over 70 million or something like that. Yes, that's the highest award I've seen in labor litigation in Nigeria. Yeah, So then we've also dealt with the issue of I think it was a level of GM or DGM or something, AGM or something like that. So then the issue of giving reason for termination, that's there. So the reason could be poor performance or restructuring, right? an employer has a right to restructure his business to be efficient. The court has no say over that. So once you've restructured and then it leads to redundancy, then the people who are redundant can go at no and there will be no liability to the employer. The only challenge about redundancy is that if you have a handbook that makes particular or special provision for redundancy, right? And what has happened is redundancy, then you have to pay what the handbook says. So again, when you're looking at whether you should, the way and manner to ask someone to go without exposing the business to liability, and you're looking at what reason do I have to give? Redundancy might be one, but you also need to look at the other costs associated with redundancy. Next slide. Now, the next notable departure we've seen, in the past, if an employee was being investigated, right, and then he wanted to resign, the employer could say, no, I'm not accepting your resignation until I finish what I'm doing. Today, there's a clear decision that resignation becomes effective as soon as the man delivers a letter. There's no need to prove that the man accepted. So if someone steals and you're investigating him, before the report comes out, he can resign. Right? However, that does not stop the proceeding from continuing. Right? Because the fact that he has left does not mean that he is no longer accountable for what he did. So the company can continue to invite him to attend proceedings, and if he fails, fair hearing is about opportunity. If you give an opportunity and you don't take it, the company could still go ahead and come to a conclusion about what happened. But the company cannot stop the man from resigning. So that's what the law is today. And this right is not negotiable. So you cannot even in your handbook, make it a provision that if one is being investigated, the person would not be able to resign. Because that's what happened in Mbeti, a Unity Bank. And then the court said no, that this provision is an unfair labor practice, and struck it down. And then upheld the Mbeti's resignation. However, there's also a benefit to the employer, which is that if the employee resigns with immediate effect, right, he loses his benefits. If an employee resigns with immediate effect, right, he loses his benefits. So that's the protection the employer gets. So I'm investigating someone today. He needs to give me 3 months notice before he can leave, right? But because he does not want to be in employment, he wants to be able to say that I resigned, I was not fired. He then throws in his paper that says, I'm resigning. Fine, right? He can't stop him from resigning, but he loses his accrued benefits. That's what he pays. Because basically what he's done is he's bought some kind of early termination of his employment. So that's what the court has held. So that's the safeguard that the court has given to employers in this case. And the case is Boye and the same Boye and the FBM mortgages. Yes? So another area where we had little in our employment law jurisprudence was conditions of work. There was little happening there until now. Now, conditions of work would look at issues like discrimination, unfair labor practice, sexual harassment, how do you deal with pregnancy issues and all that. Today, we have a body of decisions that has confirmed the rights of employees in those situations. We have decisions now that say that, look, you cannot force an employee to open a bank account in a particular bank to receive his salary. That if you do that, it's so that he can't do that. Or termination on grounds of a pregnancy. In fact, what I've seen in the decisions is that, which is what I tell my clients. If any woman is pregnant, don't do any termination proceeding. Just wait until the woman has a baby. 9 months will not render the business insolvent. Because anything you do at that point, they will say it's because of the pregnancy. So I say 9 months would not bring this business down. Allow the woman to have a baby. Because the courts are now becoming overprotective of, I'm sorry to say, of pregnant women. In fact, as we see, maybe I need to take it now. I'm talking about pregnancy. The Labour Act applies only to workers, but the NIC went to the section of the Labour Act on maternity leaves and said that this section does not use the word worker, and because of that, it applies to pregnant women. So today, the Labour Act, the provision of the Labour Act relating to maternity leave, applies to pregnant women, whether they are workers or whether they are management staff. So it's something. So now, when you're doing your conditions of service, and then you're talking about maternity leave for women, you have to go to see what the Labour Act says. Next slide. Okay, I think I've covered that, right? So now, pregnant women are protected by the Labour Act. The other area where we're seeing some movement is in the concept of co-employment. And I think it's important for your kind of business, right? Where Hess Holdings employs Mr. A and then sends him to Afriland, right? He goes to Afriland and his employment letter is still reading Hess Holdings. Then he's in Afriland and he gets promotion and he gets a letter from Afriland that you've been promoted to this. So you see all those kind of things. Or you even do a proper transfer, right? However, whilst he's in Afriland, he's still doing work for Transcorp, right? And then by the time Afriland fires him, he discovers that he's better off suing Transcorp because he might get more money from Transcorp. So he might be able to do that under the concept of co-employment. Because for the fact that he has a letter issued by one company does not mean that that company is his only employer. Now, the courts, following ILO literature, is looking at what they call the primacy of facts. What's the substance of this relationship? So the fact that the man says, I work for, my employment letter says Transcorp, but he's doing more work for maybe another subsidiary, maybe does not mean that that man cannot claim against the subsidiary. That's one. Two is there are certain obligations that actually arise in the place of work. All these issues about conditions of work, right? So if the man or the woman is employed by Hess Holdings, and then he's working in one of the power plants, right? And something happens there. And he looks and he thinks that I'm more likely to get money from the power plant. He will be able to, because that is where, if you're talking about the conditions, for example, if it's sexual harassment, for example, right? And the woman is working in that particular power plant, right? But then the issue is the people around there, what did they do? So it's something that happened in the context of her duty in the power plant. So you cannot say that because her letter of employment reads one company that people are forgotten about, maybe what you're just using that company because you believe that liability will be, that if anybody sued the company, there will be nothing to attach, right? So that's the company you're using. That person, you just have to be careful the way you structure it because of the concept of co-employment. In fact, the very recent case, Ugoke and Aero Marine, Aero Marine employed the guy, the plaintiff, right? So he has a letter from Aero Marine. And then, but then he worked with Biswal, with another company, So when he was terminated, right, he felt there was no point suing that company, so he sued Aeromarine. And then the court held that, as far as the court was concerned, that he was still a staff of Aeromarine, so Aeromarine was liable. Aeromarine argued that, look, yes, we employed him, but then we seconded him to a different company. And in fact, that company wrote him a letter confirming his appointment. And the court said, you're turning logic on his head. Do you confirm before you appoint? That if there was no letter of appointment from that subsidiary could not have confirmed. But anyway, even if all this had happened, that the concept of co-employment is still live. So that in appropriate cases, it is not what the documents say that matter, it's what the reality is. Now, the next thing that, is that the NIC is no longer a final court. I think that's the good news. That NIC is no longer a final court. That appeals can now go to the Court of Appeal as, with the leave of the Court of Appeal over, in regard to all issues apart from fundamental human rights. And for fundamental human rights issues, appeal will go as of right to the Court of Appeal. So at least most of the decisions that the NIC gave in the past, there's not a chance to begin to test whether they were properly decided or not. I think that's where, yeah. Thank you very much.
Thank you, Mr. Ike Ndoka. One of the reasons why we decided on this session is that actually we stumbled on one or two of these developments that we struggled with because we were too comfortable with what the principles were, principles of law governing contracts of employment. And so we had an option. Is either we closed it and pretend that it's not happening and continue to operate under the old regime until we're caught up with it, or we face it squarely. We decided to face it squarely. So we must have seen a number of developments here that are startling. But the fact is, it's better we know, and then we're properly guided. So we'll go into questions. I'm sure there will be a lot of questions. I have, but I don't know who will moderate this. I think you can help us. Okay. So.
I can just let you know that there are people outside. I'm heading on all of them, so they'll be sending me questions as well.
Okay, yeah, we understand that some of our colleagues joined online because this was being streamed online. So they too send questions because they must have listened to you. But we need to do all that in another maximum 40 minutes. Okay, so, yeah. Can I shoot first with your kind Obong?
Please let's count the questions so we'll know how many, we'll number them.
Okay, yeah, if you have a question. TOE style?
Yes.
Okay, so I'm number 1,
Number 1,
2,
2,
3,
3.
among 4.
Above is 5 now. She can go. Okay.
Okay,
6.
Napoleon is here.
7. Timothy 8.
Okay. Okay, so I'll shoot. My first question has to do with the issue of resignation, where you said where an investigation is going on, an employee can resign and you can't stop him. And so I paint this scenario. The employee resigns. You say I can continue with the process. I continue with the disciplinary process. The employee, of course, once he resigns, will never answer you. Most times, they will move on with their life. And then you go ahead to conclude that the employee is guilty of, the case or the issue. And maybe under your policy, that attracts dismissal. Meanwhile, this employee has resigned. So what happens? What's your remedy? How do you, So that's one. The second one is this co-employment thing sounds very interesting. But I know that, please, I want to also know if that has changed. I know that one of the requirements that a court will insist on before attending to any employment claim is your employment letter. And once you cannot tender your employment letter, the court will not attend to that claim, to that case. So where you want to claim under the co-employment thing, and perhaps you're claiming against the company that you're seconded to, of course, you don't have any letter of employment against that company. What happens? Thank you.
In his, because some might have variations of.
Before you answer. Okay.
So I just wanted to. His first question was about the resignation. It was about. I thought my voice was loud enough. Okay, it was about resignation. So to enlarge his question is because you had mentioned that the guy, if we find him liable, that we can hold on to his benefit, right? But you see, because you had mentioned the 3 months notice period. But the 3 months notice period will only be effective if he pays me for that 3 months. But if he's gone, where do I find him to pay me? So he's actually gone with my money, and so that would not be effective to me as an organization. So the second question he had mentioned was the cohabiting. So let's assume I'm an outsourcing company, Kachina & Co., right? And I have given employees to Hares Holding to help us drill oil, for example. And then, so the employment letter he has is from Kachina & Co. company. So he's gone into the drilling company and he's either committed fraud or an accident has happened of some sort, So who will be liable? I will be one liable. We Hair Holding because he's an employee of my staff. So if he decides to sue Hair Holdings, I don't think they have jurisdiction to hear the case in that. Just to elaborate both his questions so that mine is reduced. Thank you.
Now, the piece of employment letter, like I said, what the courts are looking today at is what the ILO calls the primacy of facts, right? Yes, you're required to prove that employment exists. But there's no requirement that that proof has to be documentary. So the thing to prove is an employment relationship, right? And the manner of proof does not have to be by way of a document, right? In fact, you also will see cases where it is said that an employee's contract of employment with the employer may be deduced from more than one document. So even letters that have passed, right? If you piece all of them together, they would help you establish the contract, the presence of a contract of employment, right? So that's the way I'll answer the issue. So that letter, yes, it's important, but if there's any other way of proving, right, that this relationship exists, then that will be taken by the courts, Now, then in a way that it relates to the co-employment situation. Outsourcing it's entirely a different kettle of fish. Now, co-employment is more likely to result in situations where there's some connection between the companies. However, in regard to outsourcing, right, it is not an absolute principle that there would not be the possibility of co-employment existing, right? However, what the authorities or literature, seems to saying is that it is only where the only way to explain the nature of duties performed by, quote unquote, the contract staff is by reference to an employment situation. So if what you've employed someone to do as a contract staff is something that, if you looked at it, can only be done by a permanent staff. That's what I'm saying. No, yeah. It's a permanent staff with you, but a contract staff with. It's outsourcing. Okay, go on.
Yes, where I'm coming from, I just joined this.
Yeah.
Is that we have an outsourcing, to have a lean organization,
Yeah.
we outsource some of our skills out. So the person comes to me, but he is a permanent staff. So I'm not terming him as a contractor. He's on my system. You can see him on the database. He's there. What you will just not see Coca-Cola Hellenic beside him. You will see Kachina and Co beside his name.
Yeah.
You understand? But he is sitting on the permanent staff.
So let me understand the scenario, right? Kachina & Co. is an outsourcing company.
Yes.
Now, yes. Now, ABC Limited is an operating company.
Yes.
Now, ABC Limited wants to hire a rig operator. Yes. It goes to, no, let me put it in more appropriate language. ABC Limited wants to get the services of a rig operator. They don't want to hire a rig operator. Yes, it's the service you're paying for. Right, so they come to you as Kachina, and then you arrange a rig operator. That rig operator could be your permanent staff, or it could be somebody you just hired for that purpose. Good, so it's a permanent staff. Now, it then comes into ABC Drilling Limited, right? And he begins to provide services. Then an accident occurs, right? Now, the man looks at Kachina and says, this is a paper company. I don't get money from you, right? Now, he can sue. One is, he has a right in contract. He has a right in tort. Right? So, he can decide to proceed on the basis of, tortious liability, which is about who was my neighbor in this circumstance that should have ensured that this loss does not occur. So, if it's a drilling company, he would, in tort, he would do that, right? Also, if on an objective basis, the court looks at the entire thing and they say, look, this particular drilling service, we've looked at as evidence that in no other company is it even to a non-permanent staff of the drilling company, so that this is a sham. The court could say that, look, given the nature of drilling activities, right, and perhaps because of the proprietary nature of the technology, that no company would ordinarily hire a stranger to do this, because that stranger would go away with its proprietary information. For that reason, we think that this Kachina & Co. is a pass-through company, right? That the substance of this transaction is that this was done to minimize the risk to the drilling company, right? So the courts will also strike out. They will just shut out Kachina & Co. and say that, look, the services that were provided, the primacy of the facts show that you were in an employment relationship with the drilling company, right? That's what I'm saying. So it's a matter of fact. Yeah, that's in every case, the court will always look at what do the facts tell us, right? Now, what it might then do is to try to, we did one recently in the oil and gas sector, and we are just trying to see how you can raise the hurdle, right? And then we took away the right, the guy undertook, so there's a tripartite agreement, the guy undertook not to bring any claim against the operating company, all those kinds of things. But whether the courts would, at least have a fighting chance, right? You can then have a fighting chance to say that, well, this man undertook, when he was coming into our premises, that all his claims would be against Kachina & Co. in contract and in tort. So it's not an employment contract that he's giving me, he's giving me an indemnity. Right? That if anything happens, or a non-liability undertaking, if anything happens, I'm not going to come after you. I'm going to go after the man who brought me. So we are trying to create all those kinds of structures just to see how, in this nebulous environment, you can protect, so it depends on what, yeah. What I'm saying, nobody knows, right? But at least you have a fighting chance. You have an arguable point. Yeah, so because the man will say, after saying everything, I'm going to say that, but this man signed that he's not going to come after me. That he's going to come after you, At least we'll start arguing that one. So I can't predict today how a precedent, yes. Yeah. But what you need to know is that there's some risk around it. Now, on the termination, the man wants to resign, you say no, he's committed fraud, then you want to dismiss him. You can't, right? That's what the law says. You can't. However, if, for example, the man, apart from his 3 months, first of all, you're holding on to it because he had to resign and run away. Yeah. He should have given to you. Yeah. Good. Yeah. Good. Now you then remember that this thing says that you have to pay him his entitlements. Right? But it says that in the case of this resignation, you don't pay him anything again. So if you had accumulated any benefits, for example, you have not the pension funds today, because that one you don't have control over it. But if in your handbook, right, in addition to the pension scheme that everybody's running, you have some kind of gratuity, then you can, or you can then go after the guy. You can go after him, and then if he has anything to attach, yes. Yeah. Okay, and you're not able to conclude before that notice expires. Well, I would say I'll blame the company. Because fair here, because you can then start. I mean, he has 1 month, right? If I was that company, everything will end in 1 week. Yes, you lose your benefit. Yeah. No, yeah. Yes. Which law now? Well, if you're looking at the amendment to the Constitution, it was March 2011, right? I think she may be referring to the law about the appeal. Okay. Yeah. Now, sorry, she mentioned something that I'd like to address now. There, I couldn't have covered every. The reference is now becoming an issue. An employer has an obligation to issue a reference, right? Now, it's not just an obligation to issue the reference; it's an obligation to be truthful in the reference, right? So, and to be honest. The reference, right? And not just, you also have obligation to give employment records. So these are things that are not happening because we are applying international best practice. Yes.
Number 2, yeah. One question.
Well, the issue of working hours. I'm looking at working hours. Is there any part of the employment law that protects employees, you know, from certain or very long working hours? If you say no, at what point would the court say this is too long? 8 to 8, 8 to 9, 8 to 7, you know?
Okay, I have a couple of questions. The first one is, okay, let me use the time.
Okay, do your two most important questions. So you can cover.
Okay, with respect to damages, you mentioned that when the damages the court will award are what the employee would have earned if he wasn't wrongfully dismissed. But you find claims where people earn, they make claims from the date they were dismissed to the date of judgment. Is that right? And how does the court treat that? That's my first question. Second one is, you said made to resign. I'd like you to talk about that more. What do you mean by made to resign? So let's say somebody was meant to be dismissed, which will affect his records, his reference, everything, but you advised the person to resign. Is the court going to interpret that as made to resign? Okay, so you mentioned the part where the court, you know, interprets people resigning as being dismissed. Exactly. So I'm saying that you didn't really clarify what they mean by made to resign. So if you advise someone to resign because you don't want to dismiss them, you know, because maybe of some past relationship, so you tell them resign so we don't fire you, will that be interpreted as you forcing the person to resign? So that's the second question. The third one is, what right does an employer have on an employee during his notice period? So you find people during notice period begin to misbehave because they've dropped their notice, they don't follow policies, they don't follow rules. So what level can you apply your sanctions grid to? You know, sanctions grid includes suspension, even dismissal. So somebody is on notice period, how far can you go? Because he has dropped his letter, can he just behave anyhow?
Thank you.
Sorry, after he answers Zoida's questions, can I take 3 questions from outside?
2.
No, one person isn't asking 3, there are 3 people asking 1.
Okay, long working hours, right? Well, I would say it's a matter of fact. It will be a question of fact. I mean, if it's a pregnant woman, for example, you have to be careful, right? If it's someone who has a physical condition, you have to be careful as well. What I've also seen is that if you go to the Labour Act, you're going to see working hours there. I think not more than 8 hours. And depending on the nature of work, yes, depending on the nature of the work the person is doing, you have to take a break at intervals, right? Now, if the matter gets very hot, the NIC is likely to take a cue from what the Labour Act, they've done it in the past. For example, when notice is reasonable or not reasonable, you see them kind of borrowing from the Labour Act without saying that that's what they're doing, right? So, now then there's a recent case, even though it's a sexual harassment case, right, where someone made a female staff to work in the office till 10 p.m. on a regular basis. And that was one of the reasons the court said it was unreasonable to make someone work till 10 p.m. So there's no hard and fast rule. However, I think everyone would turn on the facts of this particular case. But then you take a reference from the 40-hour week. If somebody is doing 80 hours a week, the person can bring a case of unfair labor practice, right? Okay. Now, damages, payment, time out of work. Now, in fact, the court itself, has condemned the practice of lawyers asking for all kinds of damages, right? Because once you're not working, you're not supposed to be paid. However, if the termination is unlawful, which means it never happened, then the person will get paid for the period that he didn't work. But if it was that employment is just wrongful, you can't go beyond that. And then there's nothing that makes it very harsh for the court to invoke the power to award general damages. So on that, I think, it's neither here nor there, but you can't get, I've been in court where the court said that if the filing fees were high enough, that some of the claims being brought to court here won't be brought to court. Because how will someone be claiming 1 billion damages, That's what the guy did. The guy calculated something for about 10 years. And Yeah, yes, and the court said no. What the measure is, this is fixed, so this is what I'm giving you. Now, advice to resign. If the advice to resign works in favor of the employee, I think the court will lean in favor of the employer. There's a case where the court actually said the employee should thank the employer for not dismissing him, right? You know, that the employer was kind to have permitted the employee to resign in the circumstance because the employer found and proved that what he did deserved something, harsh. The notice period. Sorry, I can't remember what.
Yeah, so the question was, how far can employer...
Yes, I mean, what can he do within the period? As long as, you see, notices that my employment will cease to have effect on a particular date, right? So if I've given notice to resign, I've not resigned. Because it will take effect, my employment will cease to be effective on the last day of notice. So in that context, I can still be dismissed, right? Yes, because you're still an employee. That's, you know. Now, what employers also do is to do a garden leave. You know, in some cases, someone says, I want to leave, right? And that's something we are beginning to introduce in some of our employment contracts, that if the man gives me notice that he wants to resign, I might as well ask the person to just stay at home and I'll pay you. Because at that point, you're no longer sure of what he's doing with the information you're giving to him or what he's doing with your proprietary business. But again, some courts will say if you don't have it in the contract, then the man will have to continue to come to work, right? Because, you know, it's... So the best thing to do is to have a clause in the contract that in such cases where the employee has elected to give notice, that the employer also might give him a garden leave. You know, yeah. Good. Yes.
We have Undubusi Oyekuna from Transport Daily Power. He's asking that an employer can conveniently dispense with the services of an employee through restructuring. Does the employee have any defense or protection at all in this regard?
Well, if he's restructuring, right, the employee would not have any. The employee would not have any. Once he can challenge it, but it's up to the employer to show how the restructuring affected the employee's work. All right. I mean, there's this rule about LIFO, but it's not. I mean, that's last in, first out, right? But it is not enforced. The important thing is that even that rule is qualified, it also depends on the employer's judgment as to each employee's skill and competence and importance to the organization, right? So, yeah.
Second question from Helen Transco Hilton. She's asked that, how do we protect our companies against claims for wrongful termination if we don't have reason or proof?
Well, reason for terminating.
Wrongful termination. How do we protect our companies against claims for employees for wrongful termination if we don't have reason or proof?
Okay.
The way I phrase mine is that it's not all the time our companies for them to go, right? As an organization, you know, don't I have a right? Because according to Nigerian law, I do have a right, you know, to say I don't want you again in my organization without giving any reason. Now my question is, how come the UK law is now overriding my Nigerian law? I work in Nigeria, my company is a Nigerian company, so why would I be taking the British law, who says that I have to give a reason? So that's where my confusion is.
That UK law, I was saying, that UK law now has become Nigerian law. That's the point we're making. Right. Effective at the date that Aloysius was decided. So that's the point. They want to be sure. Yeah, they want to be sure that for every termination, you know, there's a business case. The business case being either bad behavior or economics. Yeah.
You know, I can't prove you coming walking in at 11, giving me attitude, being rude. You can't prove that. Except you start to record. But how many times would you think of recording because the behavior had already happened before, you know? So it's not like you're expecting that behavior to happen so that you can recover and prove.
Okay, it's close to that. Okay, let me.
Yeah, I have a controversial view about this. That's actually we're worrying over nothing. Because the most common reason for services no longer required. So
to me, it's that your services, whatever you're doing in your organization, is no longer required. It's valid enough.
No, that reason is so. No, that reason is no longer sufficient.
Yeah, that this work you used to do, I no longer need it.
What might happen? What might happen? What might happen is yes.
No,
Yeah.
if you're a public company, you're clearing profits. Everybody knows it. You can't be saying, what are you restructuring? On the ground of that, you are not. You can't say all those things validly.
We're on the same page. What he's saying is that we can no longer do that.
No, you can't say services no longer required. You have to say why I no longer require your service. Which is that your position. Yes, which is that your position is no longer wanted in my. So you have to prove it. I mean, we have a case, like that where we're now. So the key, which I keep saying, is that today is about documentation. Right? Someone comes late to work, instead of saying, Nduka, why did you just show up at this time? You just, okay, Nduka, why did you show up? Then you go back to your email and write him a mail. Please explain why you came late. Yes. And no one says that one bad behavior cannot, because it's about the employer's judgment. So some of these things that, like you say, are not actually as difficult. The one I know is difficult, which is this issue of services no longer required. We are doing a case now where we have to show a chart that you have 4 units. This sector, now we have to do 3, and we have to do 3 because of this. And this man used to be in 1, so he's no longer. So we have to have that proof before they will now, just to show that position was no longer. Yes, and also the client called us and said, "Now we need to. Can we?" I said, "Don't hire yet, because if you hire now, they amend their case to say that this. They're arguing that my position was, but they've, So it's something you have to just do with advice as you move along, because they're getting too protective in this case.
For that reason, because if you don't give a reason, does it mean that the termination is not wrongful? If you don't give a reason,
By abortion, like I said, the other judge says it's not yet aborted.
And when it becomes wrongful, does it automatically entitle you to damages?
Yeah, damages will be what you have. Now, that's an interesting point, right? Now, I'm giving notice, which is what the contract says, right? 3 months. I'm giving 3 months notice. Then I'm not giving notice, right? So by a contract, I've done nothing wrong. So I've paid you the 3 months. You've earned 3 months, or I'm giving you 3 months in lieu, right? And then you come to court and say it's wrongful. Now, what the court will then look at is, what was the attitude of the employer? Was he high-handed? Because what they're looking at now is the quantum of damages. There's a finding of wrongfulness because he didn't give a reason. Now, the issue is how much loss, how much damage did the employee suffer because of this wrongful termination? You understand that? So one thing is a finding of wrongfulness. Another one is, what's the liability? It depends on the company. Some multinational companies do not want that wrongful decision, whether it's ₦1 payment or, because once they say that, there will be some reporting issues that in Nigeria they were found liable for unlawful termination. It becomes a big issue. So, but in regard to the monetary side of things, it's never going to be very much. So again, it's something you might also weigh and then say, okay, every year we'll have a budget, a provision of so much to settle this kind of claims. I mean, the highest we've seen so far is 12 months. Yeah. The practical way to deal with it.
Okay, so this is an issue we had a back and forth on during our legal COP, and it's about the issue of next of kin. So when an employee is providing details on employment, he can state his next of kin is this person or that person. Now, upon the demise of that employee, what if the person he's provided as the next of kin is not like a spouse? Because what we've come to realize is when people fill their forms, they are almost interpreting next of kin as if there is an emergency or something, who is that person you call? And there have now been incidences where your next of kin is not like your wife or blah, blah, blah. And then when we now have to pay benefits, there's that dilemma between paying that person stated on the form and who we think should be your next of kin by law. We just want you to, if you can help, give some clarification on that.
I think the tough one is not peculiar to you, right? Now, one way to look at it would be to say, that form, right, formed part of your contract with the staff whilst he was alive, right? I has told you that should this happen, this is my next of kin. No, there are two issues. This is my next of kin. That did not say that if anything happens, pay this to my next of kin. There are two issues. So if you just have a form that says next of kin, and next of kin is Ngozi K, my wife, right, then that is all it says. It did not say pay whatever is due to me to Ngozi. So that's a different matter. However, if you now expand your form to something to say that in the event of this, right, pay whatever is due to me to this person, my next of kin. So it becomes binding on the company because the company is bound to perform the instruction that has been given, which became effective while the man was alive, right? You can defend yourself on the back of that against, a claim from maybe the family or whatever. That this man, while he was alive, gave us this instruction, right? It's not like a check which is countermanded as soon as death occurs, right? So that's one way to deal with it. However, the other way also, the other challenge you have is that upon death, all the assets vest in the High Court. That's right. And the only way, in fact, they vest in the High Court with the CJ as representing that. That's why you have the probate registry. That the only way anything can come out is where you have your LOA, letters of administration, right? So, as a company, depending, if I can pay, right, and I will argue that this appropriation had been done before death, right, that the man had appropriated this particular piece before he died, right, nobody's going to come after me. Even if they went on and they sued, I'll still be able to say that, look, I paid based on what the man wrote, but it's not sufficient that it's next of kin, right? So that's the way that I will explain that. In fact, where you see the PRA, Pension Reform Act, has dealt with this in some sense, right? So for that particular contribution, the way it's dealt with is clear. But for other payments, I would say that if you want to protect the immediate family of your employees, you need to expand your form, not just to say next of kin, but also to have an instruction that payment should be made to so and so person.
How long is next? Let me just take it. Sabongi, please say you bring the microphone.
Yes, I'm sorry. I had two questions, but the first one has been deliberated. A question I have is, after we have practical examples of when we have entered into an employment contract, then in between the employment, the company comes up with a new policy, and they want to, like for instance, you kept on talking about 3 months notice. Like let's say I signed an employment contract and I had 1 month notice, and the company wants to now exercise 3 months notice, maybe for certain cadre of staff. So how do they go by it? Because if you bring it to me and say I should sign, I would sign, and I can say that was under duress because I was already working with the organization. But how does the NIS treat it? And some. Nigerian Industrial Court, something just struck me again when I was asking this question. Secondly, I noticed I've seen some cases, I've gone through some cases with the Nigerian Industrial Court, and I find that contracts in restraint of trade, they always throw it out. All the cases I've seen, I always see that they always just do not uphold that. So is there any way, or because we understand the general principle in terms of if it's not too restrictive or reasonable time and everything, but they just seem to go their way on it. So just based on your experience, I'm not saying you would have an
Yeah. What's the first one?
on the when you want to add
Yes, when you want to. Now, what I've also seen is that most employment contracts will end with that the employer reserves the right to vary the terms of this contract without reference to the employee. I've seen that. Right? Yes. And it's also in most employee handbooks that I've seen. So if you don't want the man signing at the time to know what he's signing, right? Because at that point he wouldn't have read the employee handbook. You then put in the employee handbook, right? And then say in the letter of employment that this letter incorporates all the terms of the employee handbook, and it forms part of the contract, right? So when he's signing that document, it doesn't see immediately that he's committing to something that is beyond that document. Now, once the employer has reserved to himself the right to, and the NIC has also recognized that, you have what they call the employer's rights. So it's not just a question of employee rights, it's also the rights of the employer. So the employer has a right to organize his business because it might be at that point that's the only way to save the business. So the employer has a right to organize the business in such a way as to keep it as a going concern. So that's one way to deal with that. Then the second one was the second one again. Yes, I mean, fortunately, there's a recent case actually where they upheld it, right? And they said that given the facts of that particular case, that it was not unreasonable in the context, right? So I think the watchword is this reasonable in the context, right? And again, garden leave. People will say, if the man is not going to, are you going to pay him for the period? So it depends on how important you don't want the competition is, right? So you might decide, okay, don't work for 2 years. I'm going to pay you if you don't get a work in a non-competing. So it's about how you created reasonability or reasonableness around it. And what people will say is, if you get work in a non-competing entity, fine. But as long as you don't have that employment, I'm going to pay you so much for that period. Yeah.
Thank you.
First, truly, the labor law is truly at large. I now understand what you meant when you started. I should also say that it seems to me like we now have a number of activist judges at work here. And a lot of these cases, I don't know if that's correct, but a lot of these cases seems to be coming out of the NIC. You know, and with the Supreme Court's clarification now that you can actually appeal the NIC's judgment, it also seems to me that some of these judgments may be upturned. You know, so when these judgments are upturned, the judgments that are now case precedents, you know, those precedents will now change. You know, so there's the concern that you have to also be careful how you base your, you know, your action on case precedents as they exist today. And then finally for me, the cause of my worry is where lies now the primacy of voluntary contracts, you know, between, if you like, you know, parties to a contract, the employer and the employees. Because ultimately, you know, if the contract is useless because I have to match it against 40 items under the ILO, then there's a problem. All right?
I agree with you. Those are very legitimate concerns, right? You know, like I said, employment law today is at large, and the risk you pointed out is there. You know, now we've gone into another era of uncertainty, right? When the third alteration was passed, that was the first era of uncertainty because nobody knew how the courts were going to, how the NIC was going to respond. Then we began to see a bit of stability, right? And in the midst of that stability, then we see some divergence in the court itself. So uncertainty setting again. Now there's another one. But you know, when you're doing risk management, you always assume that it might happen, and if it happens, I have to be in a position that I won't be taken out. So that's the way out, and then that's the way I would deal with it.
For time purposes, I think we've really had a good time to ask questions. I'll just invite Olamide to please come and help us appreciate our facilitator.
Thank you very much. Wow. Excellent, excellent presentation. Please, can you all join me to appreciate Mr. Unduka Ikeyi? Thank you very much, sir, for taking time out to be here. We really appreciate it. Thank you for the opportunity to learn and gain insights from your presentation. I am sure that I speak on behalf of everybody if I say that this has been useful for me personally, and I believe the entire room. So thank you very much. To show our appreciation to you for today, we'd like to present to you a token from the legal COP and the HR COP of the Heirs Holdings Group. So thank you very much for your time. We appreciate it. Thank you.
Thank you very much.
Okay, I think on that note, it's been a wonderful time. We need to excuse for the next event so that they can put this place in order. The next event starts at 6, and we're committed to leave exactly at this time. So thank you. I hope we'll have more exciting joint COPs within the group. Thank you very much. Okay, just to add, the facilitator has agreed that we can share this presentation in-house, but please do keep it confidential. He has the intellectual property over it. So you'll be getting a copy of it. Yeah.
It challenges you to do things you never thought you could do.
Maybe if you'd have gone to a private school or an MBA, you must have paid a lot to get this kind of, enlightenment.
Ça me fait plaisir de voir des frères et sœurs qui veulent se rencontrer, se connaître, et partager et créer un réseau, peut-être le plus grand réseau africain.
Vengo de Cabo Verde.
Je suis tunisien.
Je viens de la République du Bénin.
I'm from Edo State, Nigeria.
I'm from Ghana.
Zimbabwe.
Sudan.
From Rwanda.
Gabon. Uganda.
Senegal.
I'm from the Gambia.
Welcome and thank you for coming to Lagos. If you want to feel the essence of entrepreneurship in Africa, the buzz of opportunity, and the heat of competition, come to Lagos. Can you feel it? The Tony Lulu Foundation was founded in 2010 to help empower African youth, to help institutionalize law, to help democratize access to sustainable living. This is born out of my belief and experience that the private sector has a key role to play in developing our continent. And it's so...
Yeah, it's on.
Our African entrepreneurs through the Tony Elumelu Foundation Entrepreneurship Program. The program is designed to identify entrepreneurs that have the potential to grow their businesses, create 1 million new jobs, and contribute in addition to the economy. To help achieve Mr. Elumelu's vision, the foundation is supported by the prestigious investment firm Harris Holdings and by one of the country's oldest institutions, United Bank for Africa, which operates in 19 African countries.
UBA's successful impact in helping to create infrastructure and foster intra-Africa trade is helping the entrepreneurship ecosystem.
Ezeke, and he needs no further introduction.
Security and corruption also being tackled. The enabling environment is being created for businesses to thrive in the country. We hope when the time is right, young entrepreneurs like you will take advantage.
In the industry of sales, marketing and training, I think my kind of industry has a potential in Nigeria, in Africa, and of course in my local community.
And after each session, breaks and sector-specific discussions are also key for entrepreneurs to create opportunities for knowledge sharing, collaboration, and development of their business ideas.
Up to 30% of African medical drugs are counterfeit. Now, I came up with a system where in every point of sale, they check the legitimacy of that product, which again brings the problem. Why is it that when we deliver these medical products, everyone questions it, like, is it legitimate now? Are you guys okay?
I'm a consultant medical entrepreneur. I want to solve one of your problems.
I've been able to mingle with people in my field of business. And so
this forum has availed me of the opportunity to meet other entrepreneurs who, at the end of the day, would supply me floating fish